Well, good afternoon, and I too welcome you. To some of you who saw my presentation given to the council previously, some of this will be, you'll have heard it before, but we hope to have some new information in here for you as well, and we hope to, as Councilmember Moss said, we hope to be able to respond to your questions by the end of the day if possible. We began this effort at drafting, and I have three members of my office here, all of who participated, and I want to thank them for their time and effort, as well as the other representatives on the task force, including representatives of the police department who are here and of the city manager's staff. I believe council members had heard, and we had heard, considerable concerns about the enforceability of our current noise ordinance. Our current ordinance was adopted in 2014 after the court struck down our prior ordinance as being unconstitutionally vague. In trying to respond to that vagueness finding, we came forth with an ordinance that focused on objectively verifiable facts, specifically decibel limits. Those decibel limits, while in theory are a great way of going about noise enforcement, practically speaking, it created a number of problems. And so we have had repeated concerns over the last 8 years about our ability to effectively enforce the ordinance. What we've tried to do is to provide a streamlined process that doesn't rely as heavily on sound meters, and to create a hybrid penalty structure, because we've also found that the court is loath to convict someone of a criminal offense for a noise violation. And as many of you probably know, to convict someone of a criminal offense requires proof beyond any reasonable doubt. That is a very high standard. On the other hand, to have someone found guilty of a civil violation requires nothing more than a finding of a preponderance of the evidence. So for those various reasons, we thought a hybrid penalty structure might be useful in this ordinance. As I told you, we worked with the city manager's office, the resort management office, the police department, and our council liaisons in an effort to build an enforceable ordinance that was content neutral and had an objective basis. In order to get started, we did a survey of other noise ordinances in other Virginia localities, and we think we've adopted the best provisions of those ordinances into what we are proposing today. The new ordinance consists of these code sections. The first section contains definitions that are used throughout the remaining sections. The second section, 2365, says that the police department and such other departments as may be designated by the city manager are responsible for enforcement of this noise ordinance. And then 2366, the third section in the ordinance, is what is really new and we hope innovative about this ordinance. That is where the plainly audible standard is brought to bear in finding possible civil violations. 2367 harkens back to our earlier ordinance with sound level based violations. We expect that those might be necessary in cases where we have repeat offenders for whom civil violations are not a sufficient deterrent. Then we have 2368, which is the nuts and bolts of how you go about measuring for a criminal violation using sound meters. Then violations and penalties, and then the exceptions, which are also an important part of the ordinance, and I will touch on all of those in a little more detail here in a few moments. Again, the key changes is the first one is the addition of this plainly audible standard, and I'm going to talk about that in more detail. With that plainly audible standard comes the opportunity for a less onerous enforcement model. And of course, as I've talked a little bit about, and we'll talk some more about, the other key change is the imposition of that civil penalty in lieu of criminal penalties only. So let's talk a little bit about what the plainly audible standard is. It is pretty much exactly what it sounds like it is. A sound is plainly audible if it can be heard by the human ear, either with or without a hearing aid or device. So if you can hear a sound and you can identify that sound's source, then it is plainly audible for purposes of this ordinance. You do not have to be able to understand any words. You do not have to be able to identify a melody if it's music. Mere bass, reverberations, reverb is enough to constitute plainly audible. What this standard does is it says in certain times and places, if sound is plainly audible, it is a violation. I want to contrast that to what the former ordinance required. Under the former ordinance, if you were in your home and you were experiencing a loud sound that was disruptive and you called the police department had to come to your home, had to be granted access to the interior of your home, had to go to the room closest to the noise source and use a sound meter and stand there and measure that sound level from 4 feet away with all doors and windows to that dwelling closed. That didn't happen very often. And, you know, it was compounded by the fact that at the time this ordinance was initially adopted, and maybe up until today, there were a limited number of noise ordinances, of noise sound meters available to the police department. Every officer did not have one, and so if a call came in and the officer who just happened to have it isn't the officer who responded, then you had to wait for another officer to come. So you can see that enforcement using the decibel standard was not particularly effective, whereas now any officer can respond to that call, and if the sound is plainly audible in the location identified in the ordinance, that officer can write the citation and can be the complaining witness at trial. Now, I've highlighted here the text of probably the most likely to be charged subsection in 2366. This subsection would make it a violation and subject the maker of the sound to a criminal penalty if that person was using, operating, or playing any amplified sound source, including a musical instrument, a car stereo, a loudspeaker, any kind of implement that amplifies sound can fall within the scope of 2366A. And if the sound created through the operation or use of that device is audible, plainly audible, as that phrase is defined, as I told you before, inside the confines of another person's enclosed dwelling unit, that is a violation of the ordinance and can subject the maker of the sound to a civil penalty. Similarly, if the noise is audible during the daytime hours from 7 a.m. to 10 p.m., from a distance of greater than 100 feet from the noise source. So if it's an amplifier, if it's a band, if it's a speaker, 100 feet from that source, and if that 100 feet takes you beyond the property boundaries of the property on which that noise source is located, then that's a violation. So let me put that for you another way. If an operator of a noise source confines that noise on their property, whether it be more than 100 feet from the source or not, if it is confined to that property, it is not a violation. But if it is both plainly audible off that property and where it is audible, it's more than 100 feet from the sound source during the day, that's a violation. The nighttime hours, it's the same thing, except it's 50 feet rather than 100 feet. And I guess this room is probably in the neighborhood of 60, 65 feet is my best guess. So that gives you some sort of idea of the distances we're talking here. I'm not going to spend a lot of time on this slide. I've already talked about it. We believe that this new regulation is substantially easier to enforce, and therefore, because it's easier to enforce, our goal and hope, and I know this is the goal and hope of the police department as well, because we have an ordinance that is, we hope, enforceable, we hope that we'll be able to gain voluntary compliance rather than having to go write citations and take people to court. I believe we got to the point where people knew that the ordinance we had just simply wasn't enforceable, and so there was less incentive to comply with the orders of our officers, and we didn't get the type of voluntary compliance that we would hope to get going forward in the future. And it will be, and you'll see here in a little bit, it will be a hallmark of the enforcement of this ordinance to try to gain voluntary compliance before issuing either a civil or a criminal violation. If a citation is issued, this slide shows you, in the event of a finding of liability or of guilt, what would happen under the current ordinance and under the proposed ordinance. Right now, under the ordinance in place, a first offense is a Class 3 misdemeanor. A second offense is a Class 2 misdemeanor. The Class 2 misdemeanor can carry jail time. The Class 3 cannot. Under the proposed ordinance, a first offense is, under the civil side is a $250 fine, and a subsequent offense is a $500 fine, I believe. If we have to go to the criminal route, either because we have repeat violations where the maker of the noise refuses to abate their conduct, or where we have to come out with a noise meter and measure the decibel level, the criminal charges there are now a Class 2 for that first offense and a Class 1 for subsequent convictions. You've heard me, my staff will call it wine. I hope you'd call it something else, but I have in the past talked about some of the challenges in drafting and enforcing a noise ordinance. It is a complex and daunting task, to be sure, and many jurisdictions have had the same problems that we have here in Virginia Beach. Nancy sent me an article today about a jurisdiction, or the state of Florida has just adopted a new ordinance, and they already have complaints and concerns coming in from all corners. It is complicated, and there is no quick or easy fix. And part of that is because we are fortunate enough to live in a country that has a First Amendment. The First Amendment substantially limits the ability of government to curtail an individual's exercise of their right to expression. We also have noise types like vehicle noise where, you know, it's just difficult to get enforcement done on a sound that is capable of constant movement. And so you have to look at, you know, not only writing an ordinance that looks good on paper, but writing an ordinance that practically can be enforced, where the enforcement agent has the ready ability to get the evidence necessary to support a claim after that charge is written. I don't want to take us too far off track in talking about principles of constitutional law because they teach entire law school courses on it. But I will say this as it relates to the First Amendment and a noise ordinance. The First Amendment protects all expressive activity, not just the spoken word. It protects any kind of artistic display, any type of musical or poetry or any type of performance. The definition of expressive activity is extraordinarily broad. We've heard concerns about busking. Why can't you just, prohibit busking? Well, busking is a First Amendment activity. It is protected by that First Amendment. Why can't you do something about this panhandling? Well, panhandling is a form of expression, and the courts have specifically said that you cannot prohibit that First Amendment protected activity. So in drafting an ordinance, we have to be very careful about how we go about it. We have to try to avoid, to the greatest extent possible, any speaker or content-based restriction. Because if a governmental regulation is applicable based on who the speaker is, or based on the content of that speaker's speech, then that subjects that regulation to what the Supreme Court has called strict scrutiny. And that means that the government entity must prove a compelling governmental interest, not just a significant, but a compelling governmental interest. And it must serve that interest in the most narrow possible way. And practically speaking, there have been very few cases where a statute or an ordinance has been subjected to strict scrutiny and has been upheld. So it is very important that this ordinance try to be, and we believe is, speaker and content neutral. Instead, what we have are time, place, and manner restrictions, which are permissible under the Constitution. You can do this at this time, in this place, in this way, irrespective of what you're doing or what your viewpoint on an issue is or who you are. If you're making sound that's audible in your neighbor's bedroom at 11 o'clock at night, that's prohibited. It doesn't matter whether you're singing a song, it doesn't matter whether you're street preaching, it doesn't matter whether you're having a party. At that time, in that place, that conduct, regardless of what it is in violation of the ordinance. And you have to leave ample alternative channels of communication. So we're not going to be in a position to use this noise ordinance as a way of prohibiting, for example, all busking. We're not going to be able to say there's no place and no time and no sound level at which you can busk. That would still be in violation of the First Amendment. Vehicle noise. We heard a great deal about vehicle noise. And I understand the frustration. I can still remember I had the misfortune of staying in Myrtle Beach during Bike Week 20 years ago, and I still hear the ringing in my ears. And so I know that that is a significant problem, and I wish it were something that we could address with our noise regulation, but there are challenges to that. The most pertinent challenge to that, quite frankly, is what we call Dillon's Rule here in Virginia, and the statute, or the portion of it, that I have on your screen. This is a law that will become effective later this week, and it says the governing body of a city may regulate noise from a vehicle, provided that that vehicle is not equipped with a muffler and exhaust system that conforms to two other Virginia Code sections. So that's important for not only what it says, but what it doesn't say. We can enforce the noise ordinance against loud vehicles, but only where those vehicles are loud because their muffler and exhaust system don't comply with existing law. So if we can cite them for having a non-standard muffler, then we can cite them for the noise ordinance. But if we can't cite them for having a non-standard muffler, if an officer can't prove in a court that it's a non-standard muffler, then we can't cite them under the noise ordinance either. So our ordinance says operation of a motor vehicle or operation of a motorcycle within the city with a gutted muffler, muffler cut out, straight exhaust, or without an exhaust system in good working order, that's a violation. But we can't go any farther than that under existing law. And enforcing that still will be a challenge because the way the law has written, this is an excerpt from 1047. You can't offer to sell, and you can't operate a gutted muffler, a muffler cut out, or straight exhaust. That one's relatively easy. I think our police officers can readily tell you when you've got a gutted muffler or a muffler cut out or straight exhaust. But then you get to 1049, and it says, but now you also have to make sure that what you're looking at isn't either standard equipment for that particular vehicle or an alternative that has been approved by one of 3 or more national or international standards setters, standard setting organizations. So the police department, this is a law that goes into effect also next week. We're going to be working with the police department to find out and figure out how we can determine whether a particular muffler system is in violation of 1049 so that we can then cite them for a violation of both 1049 and the noise ordinance. But there's still work to be done on that. And frankly, interdiction for loud vehicles is probably better suited for something other than the noise ordinance. It's probably better under the vehicle code or the vehicle inspection code than under the noise ordinance. But we have the provision in the noise ordinance that as of this moment we are permitted to have. So let's go through a couple hypotheticals to show how this will work. So this hypothetical is a resident in an apartment building who is being disturbed by a loud party or a loud neighbor. The call could come in to either the police emergency or non-emergency number. An officer would be dispatched. That officer will first check to see whether the noise is plainly audible from the street, and in order for it to be plainly audible, the officer must both be able to hear it and be able to identify the source from which that sound comes. If it's plainly audible, then the officer goes directly to the sound source and attempts to get voluntary compliance. If voluntary compliance is achieved, that's a win. The officer will document the win, end of story. If no compliance, then a violation would be delivered if the person is there and responded, or if not hand delivered, it can be posted or mailed pursuant to the ordinance. That violation can either be prepaid, or the person who receives it can elect to have a hearing in court. And because it's now plainly audible, and the officer was able to determine it himself, the officer himself can be the complaining witness and doesn't have to rely upon and inconvenience the citizen who made the initial call. Of course, if the sound is not clear or plainly audible from the street, then the officer would interact with the complaining residential person and would go into their home and attempt to determine, if they could identify the noise source from there. Again, it would then follow the same course. If there's no plainly audible noise there, there's nothing to be done. If they can hear the noise and determine its source, then you go back to voluntary compliance, and it goes on just as I discussed before. You have a citizen who is a neighbor or in the vicinity of a loud bar or restaurant. They call the police, again, either number. The first thing the police department would do would be to check it and see if there was an event ongoing that was subject to a permit, and they would check the conditions of that permit to verify that the sound was consistent with the terms of the permit or inconsistent. If there was no permit or the sound was inconsistent with the permit, then they would either proceed civilly along the top line here, or they could proceed criminally if they had a sound meter available to them. Under the civil enforcement, if it's plainly audible at a distance, again, if it's during the daytime, a distance of 100 feet when measured either from the public right-of-way or from another landowner's property, and they could identify the source, they'd go and again seek voluntary compliance, document any success they had. If there's no success or it's a repeat offender, at that point they would issue the violation, and then you either go to court or you get a prepaid admission by the noise maker. Down at the ocean front, same thing. You first check to see if there's a permit. You verify the violation, the distance, and the sound source. You seek voluntary compliance. If you get it, you're done. If not, you go through the same steps. So I think I've done this quicker than 30 minutes. But that'll give you more time to talk and allow me to sit down and listen to your questions. But that's all of the presentation that I have at this point.
Cover the exceptions, the permit exceptions. That might be something about permits, permitted exceptions.
Okay.
That might be good for people who have questions.
So section 2370 of the ordinance provides for the exceptions from the scope of the ordinance. Section 2370 D, starting on line 473, activities permitted by law for which a specific license or permit has been granted by the city, state, or local government, including but not limited to noise generated by and necessary for the conduct of public festivals, parades, special events, and celebrations of recognized federal, state, and local holidays. We have in the code, chapter 4 of our city code provides for the issuance of special events permits. There is a very detailed process that our special events office goes through in determining whether to issue those permits. Included in that is outreach to neighbors of the event, and typically the permit would include conditions related to sound which are designed to either limit the volume of the sound or the time at which that sound can be made. Likewise, those permits are limited to, I'm not sure if it's 3 or 4 permits for a location per year. So if you get a special events permit and you stay within the scope of that permit, then you don't have a noise ordinance issue. If you exceed the scope of that permit or you do not get the permit, then you can be charged with a violation of the ordinance. Similarly, under our zoning code, some outdoor uses require what's called a conditional use permit. And so the ordinance provides in section 2370, this is line 493, and I always turn my papers around so I can't find the line number, but if you can find 493, you'll see that there is an exception. Here we go. Well, where is 493? All right, there's an exception for normal and customary use of an open-air venue for which a conditional use permit has been issued pursuant to the city zoning ordinance. So again, the council, and if you've watched council, you know this, council is very diligent when considering the issuance of a conditional use permit, of considering how that use will affect the neighbors. And so typically, if an outdoor venue is being approved, that conditional use permit will contain conditions that are designed to minimize the impact of sound and light and other conditions related to that activity so as to minimize the impact on the neighbors. And so if a conditional use permit is granted and the event is a normal and customary use for which that CUP has been issued, then likewise there would be no violation under this ordinance. Did that answer the question?
I just wondering if people had that. As I mentioned, first of all, I want to recognize the council member, Emily. She's in the back. I want Miss Barbara, you're welcome to come up front, Barbara, and join us. and she's good. As I mentioned before, we're gonna, now the city clerk is, since we have some more time, let people come up, and as I mentioned before, we're gonna take all the questions that come up, and she's gonna keep track of those. And then at the conclusion, we're gonna reserve the last 45 minutes, so I'm gonna count on Amanda to make sure we don't consume that. Mark will take back the stage and then answer those questions. I think we all have to agree that we are very fortunate to have such a great legal team representing you, not just us, but you. I think they've done a great job of trying to listen to everything, but we are here to learn some other things that we can improve or things that we've overlooked or whatnot, so we can make this even better. So with that, Amanda, I'm going to turn it over to you and call the people. And remember, it is just on the noise ordinance. If you have other questions, feel free to see me afterwards. I'll be happy to get those. But today, we just want to focus on the noise ordinance, if you would please. Thank you very much. Amanda, Ms. Lawrence, over to you.
Thank you, Councilmember Moss. The first speaker will be Brandon Beavers. Mr. Beavers, if you'll just go to the microphone there in the middle of the room.
Lucky am I to be first. Brandon Beavers, I'm the president of the Short-Term Rental Alliance. We represent over 500 members of our group. And with my official hat of the VBSTRA, our short-term rental regulations say no outdoor amplified noise from 10 to 10. So this seems to contradict that. And so which one is it? That's, from our group, what we would want to know. Is it this new ordinances trumps this, or does this trump that? You see where I'm going? And then me as a citizen of Virginia Beach, been here my whole life, born and raised. It seems like, and I listened to city attorney's presentation, we didn't have any violations of the existing ordinance, right? Or it was tough to enforce. I don't see a problem with that, right? But we have an ordinance that's in place. If there was an issue with the existing ordinance, it seems to me that we should let it do it, and putting more regulation on the citizens doesn't make sense to me. I think if the intent is to get loud bass off of Atlantic Avenue, then we should say no loud bass on Atlantic Avenue. But I see a potential monetary problem with our city budget having to defend against lawsuits as a result of the proposed ordinance. That's kind of where I'm going with this, right? At the end of the day, if this is deemed yet again, like it was in '09, unconstitutional, the city's going to have to spend how many thousands, millions of dollars to defend itself against this. So I have, just some questions around that. Yeah, that's all I got. Thank you.
Thank you for coming. Thank you.
The next speaker, excuse me, is Mark Michelson.
Could I remain here?
No, come to the
I need my...
well, you need to be speaking in the microphone for the camera to get. No, sir.
Okay,
We need you to come to the microphone.
I understand. Give me a minute. I gotta get my thoughts together.
Thank you.
Changes to this thing.
You can use that table right there and
Can I?
to put your material and allow you to reference back and forth, and you can just use the piece that you're using.
That'll work.
Thanks, Mr. Moss.
No problem. And we will not start your time until you have started addressing the body here, all of us.
Is it just for civil penalties in which if they have a permit, everything is, okay? Or does that revert to the other, federal, or what's the other permit? Huh? Special use. There's two permits, right? The cup and the special use, and they're both covered under your, see, I had it all organized in my brain, and now I'm all messed up.
But we have
Under your special provisions, that they are okay if they have a permit. So exemption applies to both. So is it civil? And criminal. Yes, sir. So in other words, my point being, you still would need to use a reader for the criminal side, correct?
We'll take that down. We're going to answer them at the end. So
Oh, okay. My thing is, first of all, special permits, event permits given by that office, Ms. Capps, Yeah. The form itself is through FOIA, I got some of the forms. And I'll mention their name, it's Blue Pete's. Most of you know my case with that. I sent you emails about it. On the form, there's no place or there's no one checking to see what classification the business is, whether it's B1, 2, 3, 4, 5, or 6. Blue Pete's is a B1 business, and they're not allowed to have axe throwing. They're not allowed to have volleyball. They're not allowed to have open air markets. They're not allowed to have off-site parking. There's several other things, but yet the permits they are obtaining are approved through that office, special permits office. So if they obtain a permit for that, and they have a band, and it's very loud, and I live 0.5 miles away, and I always hear it, then what's the action? What can I do? I had an officer come out all the time. Last time they came out, they said the reader was broke, so they couldn't take a reading. And there's only one reader, apparently, and one officer who can use that reader. So that's a problem if you're going to go back to the other penalties and not rely on civil. Because I think there should be at least one reader in every squad car, not just the captain's car, which he told me is kept. The officer told me is kept in the captain's car. And there should be an officer on every district that can read and that have the ability or training to read that device. Something has to be done under the civil penalties for restaurants and businesses. This restaurant is in the middle of nowhere. I live in Barbara Henley's district. It's in the middle of the swamp. All around it are residential area. There's no businesses. There's no buildings. It's all farmland. And I can hear this business with that loud music 0.5 miles away. On the form, it says something about, on the B1 business, on the classification of codes and ordinances. Now, I don't know if they're giving these permits without knowing what the code is, but a B1 business is very restrictive. Ms. Henley told me about that. That's when I started doing my research.
That's time.
Thank you.
Thank you. I know Mr. Candler is listening on the city side as to the zoning and what's happening there. We will answer the generic questions later as to events independent of location, but I know I saw him taking some notes back there. I know Mr. Candler will get back to you on the application of the zoning and how permits are granted. Right, Ken? Very good. Thank you so much.
Okay, thank you.
Thank you.
The next speaker is Tony Britton.
Thank you for hearing me. While I understand that noise can be disruptive and unpleasant, noise is also a term used in varying ways depending on personal preference. What may be considered noise to one person is music to another. We all have choices on what we listen to, and we all have the ability to adjust when something is not to our liking. However, we also all have the right to be heard, and we all have the right to freedom of speech. The harm of the proposed amendment is the deliberate intent to displace and silence artists exercising their rights and adding culture and connection to Virginia Beach. The beauty of different types of artists playing and performing along the boardwalk specifically is there's plenty of space to have something for everyone. There are 3.5 miles to walk, bike, or jog. If you don't care for a particular artist, keep going, and perhaps the next one will be more to your liking. Regardless, each artist has the right to perform and to freedom of expression. The Supreme Court has interpreted artistic freedom broadly as a form of free speech. In most cases, freedom of expression may be restricted only if it will cause direct and imminent harm. Shouting fire in a crowded theater and causing a stampede would be an example of direct and imminent harm. In deciding cases involving artistic freedom of expression, the Supreme Court leans on a principle called content neutrality. Content neutrality means the government can't censor nor restrict expression just because some segment of the population finds the content offensive. Additionally, this amendment is being devised without equal representation from all interested parties. It was developed by the City Manager's Office, the Resort Management Office, Police Department, and the City Attorney's Office. There's no representation from the Vibe District nor any artists. If this council wishes to get involved with local artists, there should be a concerted effort to have an artists coalition to represent local artists in these proceedings. I have an example, if I may be allowed to submit it, of a guide that was adopted in New Orleans for street performers. It allows performers to understand they operate within a certain guide and gives them the ability to exercise their freedom of expression. The connotations of the amendment, the way they are, have far-reaching implications and lead us all down a slippery slope of censorship and intolerance. If Virginia truly is for lovers, it's for artists, openness, and supportive diversity.
Thank you. Thank you so much. Michael Maloney.
Thank you all. Thank you to the city for entertaining this issue we've had in the city. I'm a 26-year resident of Sandbridge, and so with short-term rentals and music and things like that, very familiar with all those things. I have neighbors who have a band and play. I have short-term rental people that rent near me and do all kinds of things. And there hasn't been the avenue to really take care of it. The current ordinance is unenforceable and unmanageable. That's why this is coming here. 50 feet and 100 feet seems restrictive, I would agree, but I've measured where these things come from to my house, and this would solve my problems of not being able to go to sleep at 9 o'clock at night because of what's happening 250 feet or 500 feet away from my house, through closed windows and everything else. I commend you I've read through this 4 or 5 times now, looking for the loopholes, looking for what you missed, and I can't find it. I really think that this is something that is prohibitive to artists, it's prohibitive to businesses, but the Supreme Court also looks very heavily at rights as they come in effect of the people. And I've always been told that your rights end at the tip of my nose, let alone the tip of my ears. So I commend you for this, and I do think there's a place for this. It's well thought out. It is restrictive. I would have been happy with something a little bit less, but this is good, and I want to commend you for that. Thank you.
And then we have one additional speaker signed up, Joseph, and I'm sorry I cannot read your handwriting, so you have to give me your last name when you come.
It's Joseph DeBarrow.
DeBarrow.
Hi, how you doing?
Thank you.
My name's Joseph DeBarrow. I've been on the beach my whole life. Some of you know me, some of you don't. I've been running hotels for 40 years now. I run presently 2 hotels in the oceanfront. I run the Ramada Plaza on 28th Street and the Ramada on 28th Street also. I've worked in the oceanfront for Holiday Inns and Quality Inns and a couple other hotels over the years since the early 80s. The noise on the oceanfront, the boardwalk, has increased greatly over the last few years. Apparently the word got out that there was nothing that you could do about it, and people would come down to the oceanfront. And over the last 4 or 5 years, and I've got many calls to our guys in blue of people behind my hotel with amplified music, and which is disturbing my guests. I've had irate guests at my counter constantly over the years, to a point where I'm refunding money. Nothing we could do about it because the police, they had their hands tied at the time. They would come out and they would try to do everything they possibly could to stop the amplified music when they were there. They actually knew there was nothing that the Boys in Blue could do. I'm sorry if I say Boys in Blue. But they actually knew that, and whether they would comply or not, they would just be defiant. and to a point where they would come back and forth and back and forth and back and forth all the time. And over the years, it's gotten worse. And it's not so much as the artists, like people say that they have a right to play and be there. That's not the issue. I think the issue on the oceanfront, on the boardwalk, is the amplified music. You have to have permits. Bobby Malati, any beach events or anything like that down there needs to have special permits to actually be able to be on the boardwalk or on the stages. But with the amplified music on the oceanfront, on Atlantic, on the boardwalk, bounces off our hotels, and there's no noise limit. And like a gentleman said earlier, at one point in time, there was no decibel meter anywhere around. I think the only one we had was probably in Norfolk, and we probably couldn't get it down here at the time. And I guess I understand we've got one now, and we're going to address that. But still, with that said, it's very, very difficult hotel managing and even dealing with guests at 10, 11, 11:30 at night when they can't do anything about it, and you got guests yelling because there's an amplified. And I'm not talking amplified. I'm talking straight up. You could be at the amphitheater. That's how much noise it is. It is so loud, and some of them. I'm sorry. Just one more thing is that some of the music is good, but some of it's very vulgar. But we're not going to get into that. Thank you very much.
That's all the speakers. If there's anyone else that would like to make any comments.
Well, before Mark takes the stage and he's the one Mississippi thing on the speakers, I do first of all want to thank everyone who came out to listen. I think it's indicative of what the council was looking for. We really try to have a transparent process. And as soon as we try to say, well, some stakeholders are a place at the table, but others don't, which stakeholders get to be a stakeholder, which don't. So we like to let all the public be the stakeholder. And so we will still take written comments. So please don't think this is the only venue. Please do, if you see something you didn't think of today, write it down, send it to us. If you cite the line number, that's always helpful. That gives us the focus on where the differences are. But I don't think we have a lot of questions, but Mark, if you feel like you have the time you need, we'll move to his responses to the questions we heard, and then the ones that we're going to still take under advisement. While he's taking the stage, the vehicle thing is going to take some time. We're not going to get to the final answer. Schedule.
Let me know if I miss one.
Homework. We're going to have to work with the state. We're going to work with something. There's no quick solution to mobile noise. I'm not sure about false expectations. Guy, you might have.
No, I agree with that, but I do intend to follow up with that. I think certainly other jurisdictions in Virginia must have the same issue with noise from amplified noise from car radios and other amplified sources. I'm not even talking about the muffler.
Oh, I know. I think we can deal with it in the car. I can said as much with this, but the mufflers are the part that I heard.
Well, I'm talking about the music because I think, and I'll let Mark speak to that. I think Mark thinks we may have a legislative problem with non-muffler noise.
No, let me clarify that. I'm sorry. The legal challenge is with the muffler engine sound noise. The practical problem is with the car radio, because you got to be able to stop the vehicle long enough to know that it's audible from a distance of more than 50 or 100 feet, and you've got to be able, and you cannot make a traffic stop for noise. So there are practical issues with car stereo noise, but I don't think we have a Dillon's rule issue there. We just have a how do we effectively make that stop, develop that evidence of the distance and the sound level, and issue that citation. That's the practical problem with that. But I don't think we have a Dillon's rule problem. And so,
And
I don't think it is, and I will tell you that we looked across the state trying to find, language that we thought would assist us with this issue, and we really didn't come up with much. But it would be a violation, that section I showed you, 2366A, if you can prove that car stereo was audible on public or private land at a distance of greater than 100 feet during the day and 50 feet during the night, that is subject to this ordinance. So if we can get fortunate enough to have a complaint made and have somebody on the spot ready to walk over, then we can enforce it. But it really would take a very fortuitous circumstance to get that done. Are you ready for me to try to answer the questions?
Yes, please.
So it was a little bit difficult for me to separate the commentary from the questions. I will do my best to answer what I thought were clearly questions. One question was, does the short-term rental regulation of no amplified sound between 10 p.m. and 10 a.m. Trump the noise ordinances, or does the noise ordinance trump that regulation? And the answer is neither. They both apply. An STR cannot have any form of amplified sound outdoors after 10 o'clock, but if there is any sound source that is resulting in plainly audible sound at a distance of greater than 50 feet from the source at night or within somebody else's enclosed dwelling unit, then that is a civil violation. I heard the comment that this appeared to be a revenue generation measure. All I can say to that is that was never an instruction that was given to me, nor was it my staff's intent in drafting this. What we have found is, as another gentleman who spoke said, we're trying to find a balance, and the old ordinance did not find that balance. And I said the first time I spoke on this issue that we may not find the right balance this time either. We may have to come back more than once to get it right, but the balance was, I think, just based on the level of comments, clearly not achieved with the last ordinance, and so we're trying to achieve that. Mr. Mickelson, I think I misunderstood your question when I spoke earlier, so let me clarify. A civil penalty regime still applies to a restaurant. So the police will not have to have a noise meter in order to find a civil violation. They will have to determine that there either is no special events permit or that the provisions of the permit do not apply or have been violated, and then only that the sound is audible at the prescribed distance based on the time of day or night.
Question a little further. I think he was.
What if they do have a permit?
If they have a permit and they are not in violation of the terms of the permit, then the ordinance is exempted.
I have a couple permits through FOIA, and they can be stopped if there's any complaint on the noise. That's in the permit.
Mark, that's why I referred that to Ken, because that's an execution of existing ordinances, existing policies, and we're gonna have to deal with that through the city manager's office. It won't be cured by this ordinance.
Understand. I mean, when the officer came out, though, he said, I'm not gonna do that. And I showed him where it was, but he said, I'm not gonna do that. So. And I'm all for this ordinance, by the way.
Okay, I hope I answered your question.
Kind of.
Ms. Britton, I appreciated what you said very much. I agree with you that the First Amendment applies. I think I said that in my comments before. I don't think I heard you ask a question, though. If you did, I'm sorry, I missed it.
I can phrase this.
Okay.
Can you go there? It's a little easier for them to pick your voice up.
To phrase as a question, Why are we creating an ordinance without all interested parties at the table? No one from the Vibe District, no one that represented artists. There was not everybody was invited to this table, and I think that there's a way for inclusion if we can give everyone their voice at the table. And is there a way for us to do that? And one of the examples of a city who has done that is what I submitted and have thus forwarded as an email. Can we take this portion of it and create it in a more inclusive manner, respecting everyone?
Well, I think when someone says, when we have public hearings, we have these workshops, we have big comment periods, people have the ability to look at the language, as we asked, Mr. Tower in fact said that when he announced it, put strike changes and to put the content they would like to see. I was hoping today that some of the people that had specific objections would say, this is how it reads, strike that out, and this is what we would like it to see. Because there's over 1,300 neighborhoods in Virginia Beach. All of them have their own view about noise. We can't deal with 1,300 people at the table. But what we can do is give every party, where's the people over there who didn't speak, is the same right to come and speak and submit in writing what they want to see. And that's every stakeholder has a chance to do that.
And if you will call me after this meeting or send me an email, I'd be happy to sit down with whoever you think are appropriate representatives of the Vibe District and the artistic community. I welcome that.
And all the council members meet with people, but the body has limited as a body time as you can appreciate. And I think you have the ability, you have had the ability to put your concerns and say, oh, on line 43, I wish it said this versus that. Because then you get together and you're adjudicating differences versus discovery. And that's just a choice, it's a style.
Mm-hmm. I think that the way it is, includes too many things. You can't legislate everything equally.
Well, by law, it's what we're supposed to.
They're two different things. Car noise, traffic noise, and artistry can't be handled the same way.
Supreme Court says content neutral, and that's what we're going to do.
Do you have any other questions that I didn't answer?
I did not have any questions from Mr. Maloney. I think he was mainly just comments. Mr. DeVero, mainly comments about the amplified music.
I can't ask a question now.
You want to come up to the microphone? Thank you.
What I said earlier is actually true. I've been dealing with
Years. So I guess my question is, how's this actually, this ordinance, how does this actually affect the boardwalk? And is it the 10 to 10 and they have to have a permit? You know, is that where we're going in that, which is fine? And I just want to know when I have, and it's not just my hotel, it's up and down the boardwalk. I'm sure you've been down there and everyone's been down there, and the word was out that they could just sit there, and if they move from the ocean front, they go to Pacific Avenue and sit on the corner. So my question is, how does this actually affect the amplified music on the boardwalk for basically the peace and quiet of our guests?
So when your guest comes to your front desk and your front desk person calls the police department, an officer will come and they will go out to the source of the noise. They will determine whether that noise is audible. Let's say it's 6 o'clock in the afternoon. They will go outside and determine if that sound is audible from a distance of greater than 100 feet. And if it is audible at a distance of greater than 100 feet, they will ask the performer to turn it down or to turn it off. And if the performer doesn't turn it down or turn it off, then they will issue a civil violation. If that artist just moves down the road a block and does the same thing, then we're going to have to develop a protocol where the officers at the oceanfront communicate, but sooner or later there will be a written order issued under the statute that says cease and desist, and if the person continues to violate the ordinance, then he can be charged with a criminal violation over and above the civil violation.
Can I follow up just
if you would please, so we can make
So,
sure everybody.
so oceanfront hotels, that everybody knows, are
150-foot lots, parcels. Some of them are 200 feet. So I have one hotel that's a 100-foot parcel. So the artist will set up in the substreet and actually hook up to city power at times that he will do this. And they will sit there in the substreet on the boardwalk and play their music. So you're saying at 100 feet. So I have guests that are directly within, I don't know, from here to that door that's over where that person is playing his music. And I have the other end of the building, which is 100 feet away, but it has to be past that 100 feet away for it to even be an issue. Because when I have half my hotel that's within that 100 feet, doesn't do me any good because it's disturbing half my hotel, pretty much all my hotel, because the hotel is a 100-foot lot. So
Well,
I'm confused about that.
If it is audible inside the hotel room, I've got to believe it's still going to be audible 100 feet away.
And is it 3 feet inside the hotel room? Was that what the ordinance was before?
That's for the noise, that's for the decibel level violation.
At what decimal?
During the day, it's 50, it's,
75 in day, 65 at night.
75 and
And
55?
50 feet at night also. not-
yeah, it's
And
50 feet at night.
50 feet at night, and is that after what time at night? After 10 o'clock, it's 50
Yes, sir.
feet. And so physically, they have to come into the hotel room 3 feet from the door, and
No. If it is plainly audible anywhere outside a 50-foot radius on public property or somebody else's property, then it is a violation and
Okay.
it can be written.
Okay.
So if they walk out to Atlantic Avenue and that's more than 50 feet and they can hear it,
Yep.
they don't have to come into your hotel at all.
okay. I'm good with that. Thank you very much.
Thank you for asking for the clarification.
Just in terms of the power issue, you know, Lisa, we've tried to fix that, have we not, in terms of making?
Sir, we have put covers with locks on them. They have been sometimes damaged and kicked off. We're in the process now of using or outfitting with some special adapters that you can't just plug in with a regular plug. You have to have a special one.
Right.
So we're still working on it.
Just want you to know we're working on that.
Thank you very much.
Thank you.
Are there any other questions from anyone that Mark didn't ask, you thought you asked that we didn't answer? Yes, sir, in the back. No more comments, but did you have a question that you asked previously that we didn't answer?
About the readers.
About
If
the
we go to
meters?
criminal, the section 2372 of the city ordinance, a restaurant can be read with a decibel reader from the street or an adjacent property. Doesn't have to be inside someone's home. I think there's more education that needs to be brought up on that, and we need more readers within the force of the people to do it.
We took that comment, we heard it, and that's one we'll take back. I'm sure Barbara and the whole council will be engaging. I know Ken's taking notes. That's something that the manager side will
Right.
have to address with the police department. What makes sense? You can give something to everyone, but if everyone isn't using it, we haven't used resources well. So somewhere there's always common sense is what prevails. I'm sure that's the center point we'll try to get to. But we did hear your concern and that we don't have enough, and we'll figure out how that works. I'm sure that's a small expense relative to other things we spend money on.
And the police department has committed to buying new ones already, and that's in process.
We have a very professional police force. We have very good citizens too. I think if we take this in the spirit in which it's offered, I think we can make some progress. And if we make mistakes, we'll fix them. But I do thank everyone for coming.
Thank you.
I want to thank Barbara. Once again, Barbara's here, our officers. I think we all have to say Mr. Stiles and his team did an excellent job. Thank you, and the city staff. Thank you, Guy. Guy, you might have some words you want to say.
What he said. Thank you for all for coming. I really appreciate it.
Enjoy your July 4th weekend. Be safe.